this morning, the petitioner presented his third witness in the person of Rojo Joseph Metil-Nunu. And a witness statement prepared and signed by the said witness was filed before the court. And we were expecting that he was going to give his evidence today. The lawyers for the respondents, particularly the lawyers for the second respondent, Nana Addo Dankwa Akufo-Addo, raised a number of objections to the paragraphs of the witness statement. In fact, they raised objections to 23 out of 32 paragraphs of the witness statement. And the basic objection they raised was that those paragraphs, in terms of the evidence that was sought to be given, did not arise out of the pleadings of the petitioner. But, they sought to say that those paragraphs should have been reflected in the pleadings of the petitioner. However, a basic rule of law, which I'm sure was lost on them, is that in pleadings, you plead facts, but not evidence. And we had pleaded the facts that were necessary to ground our petition. And this witness statement was designed to provide evidence in support of the facts that we have pleaded. So, for instance, we made it clear in the petition that the chairperson of the Electoral Commission had acted in an unfair, arbitrary, and capricious manner. And the evidence of Rojo Metil-Nunu, together with the evidence of Dr. Kwesa White, which I'm sure you witnessed the other day on the 3rd, was meant to make it clear the extent to which the chairperson was capricious, was arbitrary, and also unfair as far as the petitioner's case is concerned. And so we were taken aback when they sought to basically throw out the entire witness statement, saying that it was not supported by the pleadings. But as you have seen, I'm sure the court took a different view, and out of the 23 paragraphs in respect of which objection was taken, it was only 5 of them that the court said should be struck out. And for us, that is a great victory. We will not comment on the substantive content of the petition, of the witness statement, because he's yet to be cross-examined on them. And I'm sure on Monday, when we return to court, the cross-examination will take place. And thereafter, if there are any issues arising out of or in connection with the cross-examination, we'll address you and clarify those issues to your understanding. Any questions?
So, we previously asked about the impact that the witness statement background will have on the case. In this particular instance, if you see paragraph 6 and 7, very serious allegations that once taken out, you should be worried about. It talks about fax machines not working and someone just walking into the strong room with documents coming from wherever and using it to collect results. You should be worried that some important piece of information is not going to be used.
Well, that is so. If you watched lead counsel, Mr. Tikata, on his feet, he made it very clear that in respect of paragraph 6 relating to the fax machines not working and people walking in with information or faxed documents and so on, that the evidence was meant to make clear that the systems that they had put in place, because remember that in first respondent's answer, the EC said they had put in place a seamless and transparent system for the collation of results. And paragraph 6 of the witness statement, which you correctly identified has been struck out, was meant to say that the system that you call seamless was in fact not seamless, that it was in fact dysfunctional, and that the fax machines were not working and there was frustration in the strong room. Of course, that is not the only evidence that we are providing. The rest of the paragraphs detail whatever took place in the strong room, and we think that ultimately, if those are taken into account, the probative value of what our witness will say will rise up. Any more questions?
Can't hear.
Pardon? Well, of course, if the objection was taken to almost the entire witness statement, you know, if you watch Akodo-Ampah on his feet, he listed 23 out of 32 paragraphs to be struck out. Now, if you take those that remained, say paragraphs 1 to 3, those are just introductory paragraphs about who the witness is and so on and so forth. So basically, if the entire 23 paragraphs were struck out, then it would have meant that, you know, we would have basically an empty witness statement that will not be supportive of our case. But here is the case: we have, you know, only 5 out of the 23 being struck out, and for us, those 5 do not materially, you know, I mean, damage the case that we are seeking to make by bringing Rojo Metil-Nunu as a witness in this matter. So that is why I'm saying that it was a victory for the petitioner as far as we are concerned. Whether somebody attained 50% or less. Are you shifting the goalpost? I don't think so. I don't think we are shifting the goalpost. And then, also, I mean, first of all, in his testimony, PW1, the General Secretary of our party, all right, testified to the issue of whether or not any of the candidates cross 50%, you know, I mean, the 50% threshold as required under Article 63 of the Constitution, all right? And of course, you saw that they brought calculators and sought to get him to calculate figures, you know, showing how many votes were won and so on and so forth. So that is what when we addressed you, we said that is the mathematics of Article 63. But this case is not only about the mathematics of Article 63. The case is also about the constitutionality of the conduct of the Electoral Commission, chairperson. And then also, more materially, about whether and the extent to which the declaration that she made is constitutional. Okay, that is an important point that we keep emphasizing. But it looks like there is an attempt in the media to reduce this case only to one issue that we have brought to court. It is not only one issue. There are weighty issues of law that the Supreme Court is being invited for the first time in the history of our constitutional democracy to determine. We underscore the point that this is the first time in the history of our democracy that a chairperson has declared, a person, president-elect, based upon one set of figures, and then subsequently, repeatedly revise those figures. The question is, and I keep saying, can you put something on nothing and expect it to stand? It will not stand. And we are asking the court to declare that her conduct in terms of revision did not comport with law, did not comport with the Constitution, and therefore should be that declaration, together with the President-elect Declaration Instrument, CI 135, should be declared null and void and of no effect. And that has constitutional consequences. Of course, we cannot comment on the constitutional consequences because that is left to the court. But we are inviting the court to declare that her declaration, together with the instrument based upon which that declaration is now law, and for which reason Nana Addo Dankwa Akufo-Addo was sworn in as President of the Republic, are unconstitutional. That is an important point that you in the media must bear in mind. Any other questions?
Now, the last time when Dr. testified paragraph that your opponents on the other side were asking that is right. Is there an indication that you will not be comfortable having Rojo testify?
Well, that is a very obvious point, in the sense that they were saying Professor White, basically was giving hearsay evidence. Now, the person who was, in the strong room with him and who can corroborate what he is saying is being invited to give evidence. And the same people who said Rojo Metrinunu ought to have been called are now saying that he should not, be allowed to present evidence in full in respect of the facts that, of events that took place in the strong room. Now, I'll leave that to your judgment, and I wouldn't want to go beyond commenting on whether or not, the evidence that, he will give will corroborate what Professor White, provided to the court.
Anka oba bejina adeka mu akasa muhu se enam nsemsem binti anka no fa abefu fidie so na obia ahwe no TV so nanso eye yenuanom a ewo eye Nana Akufo-Addo ne lawyers esoro gina wo se ensem na ye dance dini no ode abetu dwa no ensem bebre wo mo mpesi yi firimu te se mre bi se ne omo ye no se ensem omo ka nanu nso a Dr. Professor White by no. One more can say Dr. Professor White no na only easy kasa yenti. I was saying can you only easy kasa and neba. She said you only easy kasa and ankasa abanswa. Most of them semna or the by no. Edia Samian no. Omayi compesi yi eduonu mien se frimu edia Samienu. Compensation gay Sami and Sefim 23. Now, so you no Supreme Court say, emu enum pe and obey frimu. The minimum can say 32 no ye de buy no emu enum epe and be free so. And there's somewhere the buy ni na ne dodo nankasa ejina ne nan so a enye se wentinya me ya dum na doa de ba enne nipa no be wura de kamu na ne wo se o ka kira manfo no wakachire amamfo emidamase